The Verdict is a live broadcast, and the opinions expressed by the host, guests, and callers are not necessarily those of this station. The references to legal matters are based on actual cases filed in federal and state courts and are matters of public record. Every legal situation is different, and none of the information or views provided during the taping of The Verdict are meant to be legal advice. For more information about The Verdict, please visit us at www.theverdicttv.com. Hello, and welcome to The Verdict, a show where lawyers take you behind the scenes as they prosecute the most action-packed legal cases around South Florida and New York. The Verdict is all about powerful insight and analysis about how to put the law on your side. If you want to call in, you can reach us at 888-565-1470 or write us on Facebook at The Verdict. Now, let's get down to justice. Here comes The Verdict with your hosts, Jay Farrow and Janine Davis.
It is Monday. It is rainy down here in South Florida, and we are ready to talk everything law, justice, and cases.
We're taking you inside the law from a lawyer's, litigator's perspective. This is the first airing of the show, and I want to welcome everybody because this is going to be a different type of lawyer show. This is going to be a different type of law show. This is going to be almost like, exactly like ESPN plus cops plus unsolved mysteries plus the law. We're really going to go inside. We're really going to dig deep because underneath everything here is that what this show is aiming to do is give a voice to the cases that are in the justice system that nobody's talking about, or better still, that people should be talking about.
And further to that note, Jay, it's the injustices or the inequities that people love to bellyache about and no one wants to do anything about. So we're here to sort of call it out as it is, call it out from experience. You're the attorney. I'm a layperson in the office. I have an eagle-eye view of what goes on in the law, and I used to call it death by paper cut, but no longer.
Right.
It is going to be action-packed, and people get to know that they have a voice.
Let me speak from the heart for a little bit, because this is the reason why I had the thought of creating a show like this. I've been practicing law for just over 16 years, and I've done all kinds of law. I mean, from litigation, small claims, to state court actions, to federal work. I've been participated in maybe over 80 or 100 appeals in my career. And what I've noticed over time, and running my own practice now for over 11 years, is that people are afraid. People are afraid to stand up for themselves. People are afraid to confront. People are afraid that the other side has more resources. People are afraid that the other side has more power. And
so really you're talking about perception.
I'm talking about perception.
Okay.
I'm talking about a new thought about way the law can support you in 2019 that may not have existed 20 years ago, 10 years ago.
Right.
I'm talking about the means that lawyers have and available to them as they practice in order to level the playing field. If I were to say that I had a niche, and just let me go with this for a little bit, is to level the playing field. If I was going to say that I was ever had to say what is something that I want to be proud of when I practice law, it's like, how do I give all the parties that perspective of, yeah, you could fight. You could knock each other out. You can go 14 rounds, but really, what is it worth? At the end of the day, is there a better way? Why is it in 2019, right, we have all these computers and I could do legal research that usually would have taken me 20 hours, let's say, 15 years ago, but yet cases still take 3 to 5 years to figure out. And I know, I'm just throwing a little bit out there because we're just getting the show started. But what I really want to talk about is,
people will be curious as to what you mean by what you're saying.
Why does the law take so long? Why does it cost so much money? Why are the lawyers seemingly addicted to the billable hour? Is there a better way? Why are things delay? Why is it that my case takes 3 to 5 years? Can we do something about this work? Is there anything else that's possible from the lawyer's perspective, from sitting in the chair of a lawyer, to make things a little bit, not just a little bit, but more fair, more equitable? And to get things done with the client in mind. thinking about their lives.
Right.
Because every single day that a case is going on, we forget as lawyers that the client takes that home with them. They go to sleep, they have families, they have businesses, they have things that they're up to. And it's like, what is it about, getting things done with urgency that maybe lawyers have been missing? I'm throwing a lot out here. Again, this is our first show. And I'm
Yeah.
very, very passionate about why we're here, okay? Because
Yeah.
really what I wanted to discuss is the David versus Goliath stories that are in my law practice. I want to discuss what strategies that we're able to implement in order to effectively resolve a case before it even gets to trial, before it's even filed. I want to talk about the strategies that a solo practitioners can employ to take on the larger law firm, the Goliath in their life.
Mm-hmm.
I mean, there's so much that's missed, I think, as in the life of a solo practitioner. In other words, opportunities, and through trial and error, lots more error than than anything else. I've learned a lot in the last year, especially, and I feel like it's time to give a voice to those that wouldn't otherwise have a voice. I think it's
Fantastic.
time to actually talk about how can someone maneuver and strategize and work through a case with urgency to get something resolved that doesn't necessarily have like all the money in the world. I want to also talk about some of the cases that I have on my docket.
Well, it's interesting because a lot of that is going to not only involve educating the public, but also educating other attorneys that there is another way to practice. Because you're fighting, or not fighting against, but you're sort of pushing against a way of being that has been instituted culturally in the practice of law for decades upon decades upon decades. And so what you're talking about is really sort of revolutionary, because it's not only going to affect your clients, but it's also going to affect the opposing counsel. What we refer to, the people on the other side of a case are known as opposing counsel.
Right.
So I'm going to be sort of saying those terms that may seem abundantly clear, but for people who are listening who are not familiar with the law, they don't know.
See, as we're settling into this and I'm getting rid of some of the nerves, we're talking about a broken system,
Yeah.
all right? We're
Yeah,
talking
we are.
about a system that not only takes forever, but it's seemingly unfair,
Yes.
okay? And it's unfair because it seems that money equals justice, or money equals persuasion in the law. Money means that you can paper the other side, and we'll talk more about what these terms mean here
Yeah.
in a little bit.
I'm here for you guys to clarify.
But as I'm settling in here and connecting to my heart space about really why are we here, we're talking about how do we make the law accessible to people that would otherwise just say, okay, I'm not going to handle the situation, or I'm going to throw my hands up in the air and not go after what I know that I'm owed. I mean, and the thing is that getting ripped off in any iteration that it comes in is never about business. It's always personal. And the people that know
Yeah.
that you've gotten ripped off, you know exactly what that's all about. Or you
Right.
got ripped off, you got cheated. I mean, one way or another in the law, maybe 1 out of 1,000 people would go to a lawyer for help.
Well, we find different factions, right? This is really interesting because ultimately these are not legal problems; these are human problems,
Right.
and the law is a tool in order to address that. And we know this, but it's interesting because you'll have two very different polar opposites of people. You'll have people who will fight tooth and nail on the principle at it, throw any amount of money, beg, borrow, and steal in order to, fight for that right. And then you'll have other people who will convince themselves that there's no way that they can win, and very few people fall in the middle. But you have those two polar opposites, but most people are in the middle. They don't know what to do.
I
They're
was thinking
afraid.
and this is why I was thinking about creating a show.
Yeah.
I was thinking about creating a show for people and lawyers to talk about their cases. I'm talking
Yeah.
about going inside the law from a perspective that I've never seen before in a show. I want to talk about law in real time. And when I start talking about law as ESPN, I mean, going into the cases, who are the players? What are the claims? What are the defenses? What are the possibilities that are available to the parties? And we have a fantastic guest today. I mean, on our initial show, a good friend of mine, Sar Dunbar, who's a Florida Supreme Court certified mediator, a commercial litigator, a lawyer's lawyer. I mean, one of the most talented attorneys that I've ever worked with and had the honor to know. And we're going to go into a bit about the litigation process and what works, what doesn't work. Might discuss a couple of my cases that I have recently filed.
Yeah, absolutely.
And give what and go into what this show is really going to be about. It's going to be a forum for lawyers and for the public to really understand what goes on inside the case, to understand what's possible, for lawyers to actually maybe talk about their cases that would otherwise just be in the halls of the clerk's office, but would never ever have the light of day. Because listen, bottom line is not every case is going to see CNN. All right, and that's unfortunate,
absolutely.
because when cases see CNN, guess what happens? Cases get settled. Why? Because the court of public opinion and public sentiment is the number one reason why cases are going to get resolved.
Absolutely.
But some cases have that extra tinge. They have that extra a flair that gets them the media coverage that this show looks to give a voice to those cases that should have that type of media coverage but don't. I'm going to give a platform for lawyers to come on here and talk about the cases that they're actually involved in. What are their hangups? What are their claims? What is going on the other side? How can they better their case? What are the claims that they might be missing? And maybe we can give those voices a voice and give possibilities what didn't exist. And what I'm talking about is enrolling the parties ultimately in a resolution of the case. I'm talking about negotiating on a level that and here's really one of the keys of this show is the negotiation process and the resolution process.
Yes.
Because the power to resolve a case is always within the hands of the parties that are harmed or defending the case.
Right.
Up until the time that they put it in the hands of a judge or jury, and then somebody with something like this puts it down, and that's it. Okay, then they get to decide.
Right.
Then they take the power.
Right.
And so showing that there is a way, strategies and all, to be able to come to a resolution in cases that seemingly couldn't otherwise be resolved. Maybe this is the case. This will be the show to give a platform for those cases.
Absolutely. And also to talk about the fact that people are complacent. And what do I mean by that? People think that they expect things to take forever. The attorneys think it's going to take forever. The client already knows that it's going to take forever. So that complacency breeds more and more and more of the same. And that's why I say this is really a show that's going to highlight kind of, a little bit of the warts, but also with in mind that there's a better way. There's a different way to do it. You are not compelled to do it this one way.
Right. And the lawyer's addiction to the billable hour and how the whole system is set up to continue to bill and bill and bill, especially when it comes to those large law firms. Right. And this show's long coming for me. Because this is I've been in the large law firms, and I know that my being there for the 2,200 hours a year was paying for the marble floors and not necessarily any better legal representation. Okay, and when you're paying for marble floors, basically you're paying for those things that are more important to you than your actual clients. And this is my perspective, and especially when it comes down to not to settle a case. And here's what I'm saying: if a lawyer's addicted to the billable hour, they're less inclined to actually settle a case up front within the first couple of months than dragging it out for 3 or 5 years. And that, my friends, is not fair. That, my friends, is but the thing is, if you have the money to do it, then you could drag people out, through those 3 to 5 years, then the little guy doesn't get a shot at actual justice. And so, yes, this show's been a long time coming, and now I'm getting my voice. I'm actually, getting the nerves out. I'm feeling a little better about why we're here. We do have a phone line. You're free to call in and ask any questions you want. We want you to be involved in these cases, and as we go through them, we go through each one. It's going to be a dynamic explanation and analysis of what actually is happening in real time in a litigation case, taking you directly into the heart of what goes on in a way that I've never seen before in any other show. And our phone number is 888-565-1470. And on the other side of this break,
we're going to have our guest, our first guest of the verdict.
Okay.
Sar
Welcome,
Dunbar,
everybody.
Esquire.
Thank you for joining. I know if it was a little bit confusing for the first 15 minutes, it was for me. But
for the record, it wasn't for me.
Okay.
I know why I'm here. I'm good.
And we do have a sense of humor. We'll be right back.
Absolutely.
Farrell Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrelllawfirm.com, and on Facebook at Farrell Law Firm. We look forward to being of service to you. You have been watching The Verdict with Jay Farrell and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to The Verdict.
I love it too.
And welcome back to The Verdict. It's 6 o'clock on Monday afternoons here in South Florida. And this is our first show, and we have our first guest. And I want to welcome to the studio my good friend and attorney, Sar Dunbar.
Jay, thank you for having me. I really appreciate you having me on. It's an honor to be here. I'm glad I'm doing your first guest on the show.
You know what? It just seeing you like this, it reminds me of when we first met.
Welcome.
It was like 14 years ago.
That's
in,
right.
In a large law firm down south of Miami. And I said in introducing you that you're a lawyer's lawyer. I mean, you are the type of lawyer that researches, that is on point, that finds things that nobody else finds. And
What do you mean by that?
his ability to research is something that I have not been I've not seen its equal in my career.
Wow.
Wow, thank you. I appreciate you saying
his
that.
courtroom presence also is something that brings alive the research, and you don't find that. It's very, very rare. And for Sar to be able to be a lawyer's lawyer, I mean, both inside and outside the courtroom is what I mean, is that your ability to write, your ability to research, and then also go in a courtroom and just own it. I mean, it's a big deal. It's not a natural place to be inside a courtroom.
It's true. I mean, when you're in court, you're basically performing,
Right.
you know, and you're trying to persuade a judge your theory of the case.
Right.
In any of these types of situation, knowledge is power, right? So the power of persuasion. So when we go before the court, we got to know what we're talking about. We got to be
Right.
prepared. Judges hate it when you're not prepared. And the same thing with a client. The clients need to know what they're getting into, because whenever you go into court or you decide I want to file a lawsuit or I need to defend a lawsuit, where you're going.
Yeah.
What is the outline? How long is this going to take? What are my odds? What's my success? Well, if the lawyer doesn't know the law, it's going to be difficult for you to really give it any type of prognosis of what the case is going to be, how long it's going to take, or really the realistic outcome of what's going to happen. So that's the first part of it, really educating the client, knowing what they're going to get into before you just file a lawsuit and think everything is going to be hunky-dory and end up getting it to a place where it's like, well, you know, I don't know, I wasn't expecting that, the law changed, or I thought the law was something different. The lawyer has to be able to explain it to you, and I go a one step further and actually print out the case,
Right.
so the
is
client
what I'm
actually
like,
sees what I'm
this
talking
research.
about.
Right.
But on a level
That's
is that his
fantastic.
clients understand where they're going, and he's willing to have the uncomfortable conversations with the client when the law does change.
Right.
And one of the things
Under what circumstances does the law
I'll give you
change?
I've done a lot of
Please.
foreclosure work over the last 11 years. Okay, and foreclosure law, when it was as it sat in 2008, is nowhere where it is today. It developed where you had hundreds of thousands of foreclosures that went through the system in just Broward County alone in the course of 10 years.
Right.
So when I first started practicing foreclosure, when I was talking to my clients, I would say, you know, there's a good shot here based upon what I've seen with the transfers, and there's other law firms that were stamping things on notes and everything else. You might end up with your house for free, because at that time,
Right.
there
It
was
was possible.
It was possible because there was a statute of limitations which applied to foreclosure actions in Florida, and
Right.
based upon the law, I could tell my clients that. By 2016, the Florida Supreme Court came out with the decision that said, no, that's not how we see it. We're going to rule that the statute of limitations does not apply to a foreclosure case. So you go ahead and have that conversation with the client. They're like, whoa.
Right.
Right. It changes the field.
The
Right.
big difference.
Yeah.
And this is one of the things that I wanted to talk about, because we don't know. And one of the things that you do, and I wanted to get into it, is that you are also a certified Supreme Court mediator.
That's
Talk a
correct.
little bit about that.
So I've been practicing law since 2005.
Right.
So I had the bright idea, let me become a mediator, because in a mediator's role, you're not really a litigator. You're not taking sides. You're a neutral. So you're going to hear each party's perspective, and your job as a mediator really try to facilitate a settlement between the parties.
I'll go back. Let's take a further step back, because I know there are audience and they're like, what's a mediator? What is
Right,
what this,
right.
At what part of the litigation can you mediate? Like, what does a mediator do? So why don't you take
So everybody
Couple
knows what a
steps back.
judge is. A judge goes and he makes decisions on who's going to win, whether it's a plaintiff or defendant. And, you know, same thing in a criminal case, you have a judge as well. And then a jury, obviously, cases can go to a jury, and the jury has to go back and deliberate and then make a decision one way or the other, whether you're going to win your case or not. A mediator is separate from that. It's a quasi-judicial system whereby the mediator is not going to judge, he's not going to decide your case, but he's going to listen to both sides and try to basically point out things that the parties may not have thought of, the lawyers may not have thought
Right.
of, and basically say, this is your one and only opportunity to try to resolve your case before somebody else does.
Okay.
So you're not really taking sides. You're just saying, okay, this is what one side is saying. Here's some things that you may need to think about. Here's on the positive side. Here's on the negative side. And what's interesting about mediation is that it's confidential.
Right.
So you can say anything during the mediation and they can't use it against you in court or trial.
So I can walk in
Right.
and Sar and Sar's been the mediator in a couple of my cases, and I think that we were talking before the show. You've been a part of, or you've actually mediated hundreds.
Yeah.
of
Either been a
Mediation.
participant or been a mediator myself.
Does a
Yeah.
mediator need to be an attorney?
No, the mediator does not have to be an attorney.
Oh,
You know, but I
okay.
think that the thing that gives me the the advantage is also being a litigator. So I get to
Right.
see both sides. I
Right.
see it from
Right.
the plaintiff's perspective and the defendant's perspective.
Got it.
So as a
Okay, good to know.
litigator, I can also talk to the attorneys and they understand the lingo.
Right.
You know, and then I may say something off the cuff because their client may not have heard it before because they're only hearing it from one side.
Right.
But when they hear it from a mediator, he doesn't have any bone in the fight, and they hear it for the first time, that has an impact on the client.
Sure.
You know, and it may have an impact on the attorney because the attorney's like, oh yeah, I forgot about that. I may not have talked to my client about that. And that rings a bell and that may shift the focus as to whether they want to settle or not.
See, this is what
Yeah.
this is where I think the law should go, and this is in mediation, having a third party, okay, who's not a judge, who's not an elected official,
Right.
who's not doesn't just do this for their living, and it's their pretty much their only case that day,
Right.
which is important because the law is about people.
Right.
And we forget that. No matter how good my arguments, or what, and maybe you share the same sentiment, how good our arguments might be as we sit in our office, or how much they look on our yellow pads. When we
Right.
walk into court, there is absolutely no guarantee, even though we have the law, quote unquote, on our side, that the
Right.
judge is going to rule that way, because as a human, they might see it a different way.
Absolutely. They're
Right.
going to have their own perspective.
You know, and so when what you're talking about is that when you walk into a case, it's your only case that day.
Right.
And everything that happens there, it's like you say it's confidential. Speak more about that.
So when you go into mediation, you start out the mediation when everybody's there, right? And then you give your spiel about what mediation is, and that whole initial meeting is confidential. Then the parties can break out to what's called caucuses. Caucuses mean either the mediator meets with one side and the other side's in another room, or the parties and their attorney meet. That might be a caucus, or the two attorneys meet with the mediator. That can also be a caucus.
So we're not in the same room anymore, which
Right.
is I think is so
Right.
effective, because you're
Right.
not when my clients want to
people
come in, they're
are-
like, do I need to sit there with the person that ripped me off for another, like 5 hours? And the
okay.
answer is no.
Right.
We basically give openings to a mediator, and then you decide. Oh, I want to meet with you first. But it doesn't necessarily mean anything. It's just who you want to meet with first.
That's correct. And the most persuasive thing in my experience when it comes to mediation is really the law. Everybody comes into
With the
mediation,
story.
right, thinking they're going to win or they have the stronger case. But when you start to put the law on the table and it's sort of say, well, I didn't think of that, or you have a counterpoint where the other side didn't think about, that's really what motivates the sides to move off of their positions. And the funny thing, you're talking about ESPN, when you're going into court, you think you're going to win. And I'll give an example. The Golden State Warriors, they had Kevin Durant, they had Klay Thompson, Steph Curry, had all these 4 all-stars, right?
Right.
2 of them get hurt in the finals. If
Right.
you told us before the start of the season, Golden State was definitely going to win because they have a dynasty. Come to find out, they get hurt and then they lose to the Toronto Raptors. Nobody was picking Toronto to win the finals, at the beginning of the year.
Right.
The analogy is when you go into court, you may think you're going to win. You don't, the law's on my side, the facts are on my side, we're going to win, we have all this money. But then you go in and you see all these court decisions, they may not go your way.
Right.
It happens all the time. That's
What
why
is-
there's an appellate court.
In your experience, what do you think would throw a case like that? In other words, as a layperson, I would say to you, it's inconceivable to me that you could have the law on your side and lose. This is a huge thing that I think people need to be educated on, because they do forget. They think that justice is blind and fair and that there's no way you could lose, which is why it's such a shocker, I think.
The law is not an exact science. So it's not like a computer where I can just type it in and then I'm going to get the same result every time. We're humans, just kind of like an umpire with balls and strikes.
Yeah.
The strike zone's supposed to be from your chest to your knees, but
Right.
you don't always get the ball called in that time. So sometimes the ball's a little bit outside, but they call it a strike anyway. The same thing with judges. So
Right.
you may have a discovery dispute on whether or not I should produce tax returns. Tax returns is a hot one because it's a personal right that everybody has. And in different on the type of case and what's being alleged, the judge may produce it or may not produce it. So that may be the term and event one way or other, whether you win your case or not, depending on what financial documents are produced during the case.
There are literally 1,000 issues during a case that up or down that can make or break the case.
Right.
My question to you, though, I
Right.
mean, as you talk about the law being the most important thing in mediations,
Right.
I'm finding that that there's something out there that people I haven't really heard that much brought up in mediation, and that's the costs of litigation. Yeah, wait, I'll take this back. Cost of litigation is brought up in mediation, but I'm talking about the externalities. I'm talking about I don't know, for instance, like a show like this, or something gets picked up by CNN, and all of a sudden you have a company that does
Things that are not quantifiable,
that are
that
not
you
quantifiable.
did not see coming.
Right, because there's a value, I would think, in saying, look, today is the day. If you resolve this case today, it's confidential, it's discreet.
Right.
So you're talking about leverage.
I'm talking about leverage, but I'm talking about specific leverage. I'm saying about what is it going to cost your business if
course.
this case, it's first of all, cases are not public.
Right.
And this is one of the points of the show I'm going to keep hammering at, that everything nowadays gets filed with the circuit court, and it's filed forever. There's no expunging a civil record. I mean, there's a possibility of doing something, but that's extreme circumstances of reason why something would get civilly, cleared up or expunged, but there'll still be some kind of record of it.
Right.
I think that nowadays, with so much social media, and so much, you could post something on Yelp or Google or a review, and all of a sudden it damages the reputation to a business to thousands of dollars. And litigation, in and of itself, with a society that's like, you're guilty until you prove me innocent.
Right.
I mean, this is what I'm talking about. The value of some of the cases. If you actually file something that's got, it's got weight, it's just going to
Real
take
teeth,
it's
real
just going to take
merit.
time to resolve. Is this something that is ever conceived of? Are any parties, like, you've been in a mediation room, they're like, oh my God, this is going to affect my business. Oh my God, this is going to affect my life. Oh my God, if my wife finds out about something, that I did X, Y, and Z with our kids' college fund, and I don't know. But I'm saying, are those external things talked about in resolving?
So a lot of times when you have a settlement agreement, they'll have a provision in there that basically says that it's confidential between the parties.
Right.
And that you cannot speak about the settlement.
Right.
And that's what speaks to what you're saying. There may not be negative information that you want out there for everybody to know. So that's a negotiating point, a chip point that you can put into the agreement in addition to the financial aspects. I've had stuff where they just wanted an apology in the agreement.
I was just going to go
But the
there.
financial information in and of itself could be damaging. It's not that it's necessarily charged with anything else, but your numbers for that quarter didn't work out well.
Right.
Or we're going to go to break in about 2 minutes, but in the case, one of the cases that we filed, it's like when your name is out there and it's like you might have done X, Y, and Z to a number of other employees, and if you've done the same thing, this case is only going to add weight. Because I tell you what I do when I'm investigating a case, I'm going online to check out that person's name or the company's name to see whatever other case they've been involved with,
Of course.
and see if there's a pattern and practice of the conduct.
Of course.
Right.
So I'm just thinking in mediation, does it come up? Because you talk about the law, and I understand the law is important,
Right.
but is there also this talk about this external world?
It depends.
Okay.
You have to play it from my perspective as a mediator. It's different from a litigator. As a litigator, I would push that exact issue that you're talking about.
Okay.
But I would push it through the mediator to convey that message, because if I convey that message as a litigator, it's going to piss off the other side, and they're going to want to walk out. They're not going to settle.
Right.
The mediator is kind of like that buffer, delivering that information by saying, well, maybe you need to think about this. Do you really want to get this out there? What kind of harm is that going to cause your corporation or your reputation? That's kind of how you would use the mediator in that event to try to kind of nudge them without threatening them in a specific way about this may get out and this could damage your company, otherwise you need to settle with me. That's how I would do it,
Right.
as a litigator and also as a mediator, because people have egos. They really
People do have
So
egos.
this is thank you for mentioning that, because on the other side of this break, I want to get into how the egos play into the game of the law.
Let's take a minute break and let's talk about that on the other side of this break. I like where this conversation is going.
awesome.
Farrell Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrelllawfirm.com, and on Facebook at Farrell Law Firm. We look forward to being of service to you. You have been watching The Verdict with Jay Farrow and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to The Verdict.
And welcome back to The Verdict on Monday evening here in South Florida. I'm your host, Jay Farrow.
And I am your co-host, Janine Davis. And right before we took that commercial, we started to talk a little bit about egos and how they could influence mediation, the outcome, but really litigation. I've got my own view as a non-attorney on how that goes.
I don't think there's anything more expensive than ego in the law.
Oh, well, 100%. And in fact, we've seen in our own cases how the egos are going to ultimately cost the defendants in some of the cases that we have.
It's not just the
millions
defendants.
of dollars.
The attorneys.
Well, the attorneys is one
and
thing.
the attorneys are going to get a bruising too. But
and the attorneys, as a matter of
well,
fact.
but in fact, the attorneys in many of the cases are the driving force behind the unreasonable trajectory that some
I'm
of
going
the
to say
cases
this.
take.
I believe in what SAR does more than I
do
believe
too,
in
in
filing any lawsuit.
Yeah.
I will attempt pre-suit mediation 100% of the time, all the time.
Yeah.
Because I believe mediation works. I believe that the parties are served by it, and I believe that it's my job to even look out for the other side to get the parties to mediation. I believe in it that much.
Absolutely, I agree with you. And this is why we spoke at the beginning of the show that this is really also about education. People do what they know. You don't know what you don't know. And if you are not even open to the fact that there could be another different way, a different possibility, you continue to do more of the same.
It's true.
So talk to us a little bit about how do you manage the egos in the room?
So let's talk about egos from the lawyer's perspective and also the parties.
Yeah.
So at the beginning, the lawyers select the mediator. So you have mutual respect between the attorneys
Right.
towards the mediator. My job is I'm looking at the two attorneys and seeing how can I make them respect each other. If you can get the two attorneys to respect each other, that's going to flow down to the clients. That's the key. So if it's back and forth, sometimes attorneys get into it and they sort of take over the identity of their client.
Right.
And they think that they're better than the other attorney or they've been
Oh, yeah.
I've made
practicing
the mistake.
longer than the other
I've
one.
made the mistake.
You really, when I get into a case, I look at the attorney as an ally.
Right.
Sure.
We're
course.
just actors in this game and trying to advocate for our clients. But at the end of the day, we have no bone in the fight. At the end of the day, the lawyers are the ones that make the money. So we're both kind of into it. So how do you get the lawyers to understand that and do what's right for the client? Because like you were saying at the beginning of the show, you may have lawyers that are trying to milk it. They got the billable hours and they're trying to, you got to find that out at the very
I want to
beginning.
ask you this question because I don't get a chance to ask you if we were in action mediation.
Right.
My issue is this: if I prepare a demand letter in my cases, I've niched mostly to civil racketeering, and we could talk more about that in a little bit. But I've niched down to this practice area where I see the other side has done something tremendously wrong.
Right.
To the extent where they may not recognize it or not, but they're committing crimes while they're doing their business practices.
Correct.
And in so doing, they're called predicate acts, and this increases the amount of damages to 3 times fold. It also provides an avenue to add other people to the complaint that might be involved.
Right.
And but I want to serve it on them first. And I serve it out with the process server. I make it because it's serious, but I give a time frame. I'm like, look, this is what it looks like on paper. And I work with ex-CIA, ex-FBI. I had a ex-Secret Service officer that I'm working on in this case that I'll talk about in a second. And I said, look, this is the expert reports. Here's everything. Now, I don't have any interest in filing. My client doesn't want to file. We can discreetly handle this at a mediation. Let's all go to mediation. Now, the client on the other side has got to be like, oh my God, and thank God. In other words, like there's a part of them that even though they hate me for what I just wrote them, and
they've been outed,
right?
And they can rest
But
easy
I'm
after a
not
while.
going to destroy their life. I'm not
Right.
looking to do that.
Right.
I'm not looking to make this public. I'm looking to say, okay, let's go to the table. Now, my thought, and I wanted to ask you this, is that how do I get that other lawyer to not be so concerned with the bill of hour? Because a civil RICO case is like a gold mine on the defense side if it's billable and the other side has money. And in my cases, they do.
You talk to them like you and I are talking right now. Look, man, I've been there. I've been where you're sitting. I've been on both sides of this. At the end of the day, I got no bone with you or your client, but I got a job to do.
Right.
You talk to them as if they're your buddy and see what kind of makes the person tick. Some
Yeah.
people you're never going to get through them because their egos are so
Right.
you got to kind of win in court, and then when you get them losing a couple of hearings, then they're able to break through. I've had that happen as well.
Okay.
But if you come at them like you're a buddy, you're not pounding your chest, you're not typing emails with all caps and explanation points.
Yelling at them in email.
We have our means of letting each other know.
You kill people with kindness.
Uh-huh.
You're just so kind. Even if they're yelling at you, you're just so kind. I understand your position. I get it. I know it can be frustrating. I mean, the compliments are almost tearing them down because they want to react. They want to have that reaction because that's all they know. All they know is to litigate. All they know is to bill hours and to drain their client as much as they can. But you tell them, look, there's another way. Maybe there's a way we can get something out of it, and you offer mediation at the beginning.
Right.
If you can't settle it with a demand letter, you tell me what your client wants. Here's what we're proposing, and oftentimes they'll get, well, I'm not going to bid against my client. Well, here's the offer, or here's the situation that I think we can resolve the case. Tell me what your perspective is. Hell, we can even go out, and have coffee so we can talk about this. That's the kind of way that I think you can sort of massage it to kind of get on the person's, good side, so to speak, to try to get what you really want.
Because my complaints that I serve with the demand letter with the expert reports,
Yeah.
it's heavy-handed. I mean, I'm including everybody. I'm including the directors of the corporation, because if they're working together to rip my client off, it's civil racketeering,
Right.
then in fraudulent transfer, their wives, spouses, parents,
Right.
In some case,
in
children.
some case, children.
Right.
Anywhere the dirty money flows, from my experience as representing bankruptcy trustees,
Yeah.
I get to go where the dirty money flows.
Right.
And so if I'm putting all these, I put all these people together. I have this case that I filed against Insurance Office of America about 4 weeks ago. Okay. And we did this process of, I served a demand letter and complaint, and then we did attempt pre-suit mediation, and now we're in litigation. So now I'm looking at this case from like, okay, how do we get to a point where there's 1,000 agents at IOA, 1,000, and
Right.
we've unearthed that there was this they've been looking at this 5% fee, where they've been calling it a risk management fee, and they took it from our client, and the way that they claimed the damages from our client. Now I'm looking at this case from a perspective of like, how is it possible that we got to a point where you have all of this stuff and all of this evidence and everything else, and we cannot enroll the other side into a conversation?
Well, I think it is what Sarah is saying, ego and pattern and practice. And the other addiction that we haven't spoken about just yet is the addiction to being right. Okay. So that is always driven by the ego, no doubt, but it's an addiction that is as dangerous, as destructive as the addiction to money. And that goes on both sides. And one of the things that I wanted to ask you too, that I think is so interesting. So I've always known that a lawyer is a fiduciary. For people who don't understand what that means, could you
I like
please
where you're going with
explain
this.
it? Because this is where this is getting to. This has a very sort of moral connotation to it. And a justice connotation to it. So could you please explain what a fiduciary is?
Sure. Like different things, a fiduciary can mean different things to different people. But as an attorney, you have a fiduciary duty to your client.
Correct.
And we have ethical rules and guidelines that we have to adhere to our client. For example, you can't break confidentiality because you have a duty to keep those confidences confidential. Obviously, if you have a retainer agreement and you have money in your account, you have a fiduciary duty to keep the funds of the client, sacred and not to, disperse those funds inappropriately. That's just some small examples. But, when you're in a mediation, you kind of have to remind the lawyer of their
Right.
fiduciary
That's-
obligations.
that's what I'm
because
going with
the
this.
right, me
'Cause how
too. Because
often
the
do lawyers-
fiduciary duty is also to keep your client's interests above your own, and that includes your pocketbook.
Because I've seen it. I've seen lawyers
Right.
know that the next 6 months of litigation are going to put their kid through
through
school.
private school.
Right, and
Yeah.
they've banked on this because you have all the ingredients for a great fee. You have on the defensive side, and your client has money, and they've done something that's completely not just questionable, but on paper it looks
Right.
pretty bad. So that on the defensive side at $450, $500 an hour, that you're going to be making hundreds of thousands of dollars. How is it? And this is where I want to get, like, how does that happen?
Right.
Because we as lawyers, I can't just say, look, man, I know what you're doing, and that's kind of, I mean, you could, but that's not how I operate.
Well, right, we're not going to
You
get
can't
anywhere
write that
doing
in an
that.
email. You can't write that in an email saying, I'm like, I get that there seems like there's a financial consideration for you, but where is that? Where's that space? And where do you find it? And how can you make it win-win?
Well,
Right.
typically, the lawyer can't speak directly to the other party on the other side. We're
Right.
prohibited from doing so without the
100,
client
yeah,
there.
correct.
But in mediation, you can. You
Right.
know, so for example, let's say what you
so
just.
what would that look like?
So for example, each side gets a chance to do an opening statement,
Right.
and so if Jay's talking in a mediation about attorney's fees and costs and how much it's going to cost, he says, "Listen, nobody's going to win here except for the lawyers. It's going to cost you
I've
X
heard
amount of
Sarah
money.
say that.
X amount of money to try this case. My client's going to hate me because we're going to be spending all this." You're really talking to the other side because you've already
Right.
told your client, this is what I'm going to say during mediation, so be prepared for it. Whether or not that's true or not, again, we're actors. We're playing this game and we're trying to persuade the other side. The power of persuasion in mediation is you're trying to persuade the other side as opposed to a judge, because both of you have to agree unanimously to settle the case that day as opposed to a judge doing that.
Right.
So what Jay just said about this is how much it's going to cost, you going through the spiel to the other side to convince the party, not the attorney, because the attorney's saying, "Oh, I wish he would say that. I don't want
Of
him to talk
course.
about how
Right.
expensive I'm going to be."
Right.
But you're
Right.
also deprecating yourself by saying, "Look, I'm going to make money off of this." And so the
Yeah.
other side's going to think that you're being more
Here's-
honest because you're doing it in front of your client.
Right.
Here's where I'm going with this though. If there was a conversation out in the legal world
Right.
that you could have a flat fee up front in a defensive case, like you could walk in my door and you have a defensive case on RICO and I'm evaluating it and you've got money on the side, I'm going to say, listen, it's going to be $100,000 flat fee. I'm going to take this case for 2 months. I'm going to do my best to defend you, and I'm going to do my best to get your fees down, because I know that because you're in a situation. Here's this is the saddest part. If you rip somebody off in business, you're making money off the situation. I'm going to say this again.
Yes,
If you rip somebody
absolutely.
off in business, 9 times out of 10, you're going to make money off of it. So, like, if they ripped off our client in the IOA case for $6 million, ultimately, is that going to happen at the judge or jury? Probably not. Okay. Is there a possibility that the other side could negotiate with me to get me down less? Of course, especially at mediation. Actually, SAR's job at mediation is to get me off my number.
Right.
Is that going to happen? Yes. So here's the thing: what if the attorney from get go says, "Look, man, it's going to cost $100,000 to take this to mediation." This is why the addiction to the billable hour is what costs the client's money. This is why this
Right.
show is so important, because
Right.
I'm not just speaking to my clients, or I'm not just speaking to I'm speaking to all lawyers of how do we all make money and make this win-win
Right.
for people out there, instead
Right.
of being greedy and saying, well, I'm going to take this 6 months and I'm going to pay for my college education or my kids' college education. That's wrong.
Well, 100%. But it also comes from such a scarcity, old and sad mindset, if you think about it, because when you have a better, healthier relationship with the public at large, guess what tends to happen?
You get more
You
cases.
get more
Get more
cases.
cases.
Exactly, let's
You
say.
resolve them more easily. You have a flow in your life, and guess what? Suddenly, that addiction to the billable hour is becomes abundantly apparent that it was the shackle that had you in this adversarial thing. We just heard of a case where this poor woman got a bill from her attorney for like $20-something thousand that she was not expecting.
Right.
She's gone totally underwater. She's freaking out. This is why people at large think that attorneys are greedy.
Right.
They're not on their side. And we have this conversation. It's a systemic problem.
Listen, I can look at a case and say, I know what this is going to cost. I mean, and I don't want to have that conversation with my client because I want to tell them, okay, you give me the retainer for $15,000. I do want to have the conversation now, because that's the conversation I'm having with my client. But I'm
Right.
saying the other side, it's like this is the other thing, is how do you make this now create the conversation that on the defensive side of one of these cases, it's like, okay, when we take a look at this with the idea that why don't we go to mediation? Because by time mediation with the federal people that we work with, I already know what you've done. I pretty much have all of the discovery that I could possibly
And we
need
already know
to
that
prove
it's
the
pattern
case
in practice.
on
This is
day
not a
one.
one-off.
Do I need to send the ex-Secret Service guy into your office? Not necessarily. Does it going to scare your office? Yeah. Why are you doing that to yourself? I have no clue.
Again,
is it going to
ego and
happen?
right.
But it
Trying
doesn't
to be
have
right.
to happen. Why I think that underlying this though is a conversation of lawyers. It's just a matter of, this is a huge case. And it's a possibility. Listen, I could be, making it up in this particular scenario, but I'm saying it exists out there.
It does.
So,
Absolutely.
so the other thing that's the power of persuasion that's even going to buttress what you're talking about with the attorney's fees is one of the tricks that I do as a litigator, and I encourage all attorneys to do, is you have this deposition set after the mediation. So in other words, you notice the
Got it.
deposition and you go in there because something's hanging over the other side's head. Because everybody's a tough guy until they have to go under oath and have their deposition taken. I've seen it all the time. Either there's a big motion coming up, where there's a deposition that they have to go under oath and they have to testify to, and people don't want to testify.
Right.
And that settles cases too. But if you go on a mediation sort of cold, so to
Right.
speak, and it's hard to do it before the case
It's
starts.
hard to do it before the case
but
starts.
If you have somebody's deposition noticed, and it's either we settle today, or we're going to have depositions like 10 in a row, that's real. That's
Yeah.
another lever that you can hit against people, and that'll make them blink.
We have small lawyers tip of the day, or any lawyers the tip of the day. Schedule your depositions right after a mediation, so that way you have a conversation of, hey, you're about to spend X amount of thousands of dollars by going through these mediations.
Right.
So it's mediation set and depositions just in case. Is that what you're saying?
Yeah, or
Yeah.
hear summary judgment hearing, or
Right.
trial. I mean, you can do all different types of things to
Right.
put pressure on the other
Right.
side. Because what
Right.
pressure breaks pop. So you got to put pressure on the other attorney, because you got to prepare for the deposition. I can tell you right now, a lawyer is not going to want to prepare for a deposition and prepare for a mediation. They're going to want to do one or the other. So you got to be strategic in the way that you're doing it. Sometimes you may do the notice of mediation, and then do the deposition.
Right.
Right.
You don't
Right.
have to coordinate it with the other side.
Right.
You could just set it.
But-
At least it's 7 days out.
And I want to, on the other side of this last break, I just want to talk about the being right in the law and what that might cost.
Okay.
And we'll be right back
Absolutely.
in just 1 second.
Also, just right before break, I just want to give out
Oh.
our phone number, because we were told that people are calling in, but they want to be discreet. So please call us, and we'd love to talk to you. 954-252-9818. Thank
That's
you.
954-252-9818.
Farrell Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrelllawfirm.com, and on Facebook at Farrell Law Firm. We look forward to being of service to you. You have been watching The Verdict with Jay Farrell and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to The Verdict.
And welcome back one more time to The Verdict, in our initial show. And we're here with our guest, Sar Dunbar, and really appreciate all of your insight.
Thank you for having me.
Yeah,
The
absolutely.
discussions about
I've learned so
mediation.
much today.
And,
Fantastic. Thank you.
Right before the break, it just hit me, because this idea about the law. And,
Right.
yes, we're trained to do the law, and yes, we're trained to understand it, be able to present it to a court in order to, explain why our side should have documents, why we should win a summary judgment, why we should win a trial,
Right.
why the past decisions should affect this particular case.
Right.
And I say that has its place.
Mhm.
But I've seen recently, in this past 6 months especially, is that people have this thing where I'm so right about the law, but there's not a conversation of how much that costs.
Right.
Right.
And one of the things that I saw at this just talking with lawyers in the last 6 months is this, don't you know about this statute, and don't you know about this, and I said, really, at this time, don't you recognize that I have an argument. By the time I've written something to you, you've seen where my argument is. You might be right on this. It's not going to get rid of the case. You're still going to have to go through the process, the public process of litigation. And
The painful process at times.
my point on this show is there are external things that nobody thinks about.
Right.
In this Insurance Office of America case, okay, they have John Ritter and his wife, Valerie.
Rittenauer.
They created this company out of nothing, and they built it for 30 years. And through the course of time, and when they met my client, I don't know how many other people they've done this to, but
There are others. We know of others.
Right. And so, but the thing is this: how is it that you get so right about the law that the conversation also is say, okay, this is possibly what it might otherwise cost your company, the reputation, and otherwise. I'm saying that there's something that I'm missing here, okay? Because and here's what it is. It's that when people think that they have that much money, it's been my experience is that they know that the process, the old guard process of 3 to 5 years of litigation, most people cannot stick and hang with that on the side. If you are just that lowly insurance agent, as it goes to the IOA, or if you're just the lowly consumer in some of the cases, that you're not going to have a lawyer that's going to be able to stick with you on an hourly basis to take you through 3 to 5 years of litigation. And I'll say, each one of these cases that I've done, the initial out of the box from a large law firm is you're violating Rule 11, which is this the concept that you're about to file something that's frivolous with the court. So I'm going to come
Right.
after you directly,
Meaning the attorney.
meaning the attorney directly. And I
Right.
used to never ever see that. That was like a something that you would hear about, but you never saw practice until it really got to foreclosure. And then from then, it's seeming like the larger law firms go to, as far as the strategy is concerned, to take a small law firm out is this idea of
Intimidation
sanction.
tactic.
Intimidation
Correct.
tactic.
Right.
Well, and I also call it lazy law because after a while, you throw this threat around and they think that that's enough. They've already done their job because they are expecting for the smaller lawyer to buckle. First of all, they're expecting the smaller lawyer to buckle under the threat of their license. And secondly, because also, too, they know that the resources of the large law firm could be very intimidating to the smaller attorney.
So at the end of the day, whenever you file a lawsuit, no matter how big the law firm is, no matter how small the law firm is, it's done on a piece of paper, right? That at the end of the day, they don't go up there and say, which law firm did you go to? What law school did you go to? How long you been? Judges don't care.
Right.
What does the law say? So if you get hit with a Rule 11 or 57105 in state court, you just got to have a good faith basis.
Right.
You got to have a case that supports it. So at the very
100%.
beginning, that's what I was saying, knowledge is power. You go
Yeah.
and you talk to your client and you sit down with your client and you say, this is the case I'm relying upon. This just didn't come out of thin air from Federal Law PA. This came
Right.
from this case.
This came from
and
this
here's
case.
why I think we're going to win. So when they do hit you with that Rule 11, which they're ultimately always going to do to
Always
try to
gonna do.
intimidate you,
Right.
you smack them with this case.
Right.
And that's all you need. Doesn't guarantee victory.
Or I smack them back with the counter Rule 11.
Yeah.
But
Right.
but what you just said is so powerful, and I don't want to miss this. Every single time you file a lawsuit, it's on a piece of paper.
Right.
Okay, it's got the same black ink. It's still 8.5 by 11.
Exactly.
And at the end of the day, the judges don't care who filed the lawsuit. Okay, it has claims that it lists for, in my case, like your civil racketeering, fraudulent transfer, breach of contract, fraudulent misrepresentation. It goes down the list of the counts, and then you just hash it out in court. So when you're there, okay, all of those external things, and this is the argument that I'm going to pound my my gavel, my this, is that
do
there
that all
is
the time.
more to lose in litigation than the case. There's more to lose: time,
The one thing you cannot buy or ever get,
Get
back.
back, right.
And this is-
reputation,
yeah,
legacy,
absolutely.
and ultimately, time. I mean, it to me is the biggest waste of human resources
Right.
when mediation's available to you.
And it's inexact. Let's go back to my
100%.
Golden State Warriors example.
Exactly.
They had 4 All-Stars. They had won 2 championships. They're the Goliath.
Right.
No one's picking the Toronto Raptors. 2 injuries, that's it.
Right.
You think
Right.
everything is going to go your way. We're going to hit shots, and
Yeah.
all of a sudden you
Yeah.
and then you lose.
Yeah,
Right.
you just don't know.
and you lose,
exactly.
and then you lose big.
Yeah.
So
But pointing to our cases, some of them we are able to settle at mediation, and for those who are so stuck on being right and to their addiction to their pattern of practice and the whole thing, it's going to cost them so much more. Not only what they're paying for their attorneys,
Right.
but ultimately what we settle for is going to be exponentially more potentially
because things have
than
cost
what
more.
we could have.
Because I have because now by the time if I have to go file the case, now if we've hired, like, let's say, this ex-Secret Service guy to go into IOA, it's like now I have to pay an expert, and all of these become costs, and all the costs are retrievable under the statutes and
Right.
and the law. So yes, that's what's going on. It's not just what you see; it's the loss of business, it's the loss of time, it's the
it's the
expenses.
loss of your reputation, which also, my goodness.
But the thought is, I'm too big, ego. And the thing is, when you
I'm
have
right.
a lawyer backing you up saying you're right about the law, with their underlying motivation is the billable hour, you have a recipe for disaster. That's how businesses are no longer here. I mean, that's where the Enrons explode. I mean, it happens when people think that it's never going to be me. I'm never going to get caught. And if I did get caught, my lawyers are so good that they're going to figure it out.
Absolutely.
And the thing is, there is an alternative, and I'm glad that Sar is our first guest, because he does exactly the work that I believe in, getting a case resolved beforehand. And most people don't realize, I think most lawyers don't realize, is that there mediation's available before a lawsuit gets filed.
Absolutely.
And nobody's using that resource. It's like, you can go to a mediator. No one says you're required to, in every single case, federal, state. Am I wrong? To go to mediation now.
They're going to order it anyway.
They're going
The
to
judge-
order it anyway.
Yeah.
So why not use this tactic beforehand? It's a couple $100 an hour, or maybe $3, and then you go through it for the day. And if you can resolve it, you're done.
Right.
Yep.
That's it. It's
That's
over
it.
with.
Yep.
And I think this is the effective tool out there that allows David to go out after Goliath, is to enroll the other side into a pre-suit mediation. But there's other things that you get to use. I mean, we've been using our investigators and everything else to do our homework beforehand. But
Yeah, the one other point I was going to make is that, it's not like the old days where everything was filed with paper and you had to run down to the courthouse. Now everything's electronic.
right.
Yeah.
And you have PDFs. So if you get like a stack of papers, you can just do a PDF search to really find out what you're looking for. Back in the day, these law firms are just in boxes and boxes and boxes. You put it in a room and you're trying to find a needle in a haystack.
People don't recognize this too, and I want you. Let's just expound on this for a second, because we have 2 minutes left. What Sar's talking about is electronic discovery.
Yes.
Everything's in PDF. Everything's searchable. So what used to be where I used to have to go through literally boxes and boxes and boxes of material, I
Right.
don't have to do that anymore.
Right.
A couple searches, and I'm going to find the information.
Exactly.
And I can find the smoking gun without having to go. So there's nowhere to hide the smoking guns anymore.
Exactly.
This is wow. Technology has made it such that you cannot hide the smoking gun in the law. That one case that is directly on point, you're going to find that in a couple hours worth of research. That smoking gun document, you're going to find it in their thing. And if you're hiding it, someone like that ex-Secret Service officer is going to find it and find it anyway.
Right.
So it's all there. And so the purposes behind where there used to be some gamesmanship in this process,
Right.
it doesn't exist anymore. There
Right.
are no more secrets.
Right.
There's no more secrets.
Absolutely.
What you can find in your cell phone, I keep telling people, because we're working with all these ex-CIA people, is like, don't use your phone if you ever period, for anything, because anyway, it's been a fantastic show. Sar, thank you for
so
being
much
here.
Thank you guys for
being
having
here.
me.
Guys
Thank
here
you.
next week
Join us again next week, same time, same channel
on The Verdict.
on The Verdict TV.
All right.
Thank you, everybody.
Bye-bye.
Have a good evening.
Bye.